parenting time coordinator or parenting time supervisor in this matter. The court called this as a witness, and it turns out that I do have that authority. I was reminded by a Supreme Court justice last week during some of our training that I do have the authority, which is odd because the authority is granted to me to call a witness, but I'm not allowed to sign the subpoena. Either the presiding judge has to sign it or one of the practicing attorney or the attorneys of record. Luckily, Mr. Crow did send the subpoena. So that witness will be called. But that is the only witness left, correct, Mr. Crow?
That's my understanding, subject to rebuttal, Your Honor. That's
yeah, subject to rebuttal. Yes, of course. All righty. Then let's go ahead and proceed. If you can bring in the witness, ma'am. I guess for purposes, Mr. Crow, I'll let you do the examination, but I'll let you do it as a hostile witness. So if you want to use leading questions.
Thank you, Your Honor.
That way, Mr. Tenhor, you can see the tenor of it, and you can base your questions based upon that.
Yes, sir.
Okay. I try to let the attorney go first. That way you can get the gist of what's happening. Ms. Van Zee, can you connect, please? Julie, if you could unmute and maybe turn on your video.
How's that?
Perfect. Do you have a video?
Yes.
Okay. It'd be nice to see you as well.
Yes.
Welcome.
How's that?
All right.
Great. Thank you.
All right. Welcome. Maybe a little uncomfortable, Ms. Van Zee, but the court has called you as a witness in this matter. Because of testimony
Yes.
of the parties, I needed the actual person who is uninterested in this case to bring in and bring forth testimony in this. The court will not be questioning you. I may have questions at the end for any questions that I might have left, but the attorney will question you, and Mr. Tenhor will question you. Will cross-examine you then. Okay. So, Ms. Van Zee,
Yes.
if you care to please raise your right hand. All righty, ma'am. I'm going to let Mr. Crow question as a hostile witness, and that's just a word that's legal for basically it allows him to ask you leading questions because he did not call you. Therefore, for him to examine you would not be appropriate. On examination, questions are who, what, when, why, how. In other words, all the testimony comes from the witness. On cross-examination, you're allowed to ask leading questions that can only lead to yes or no answers. So I'm giving him that opportunity to ask either form of those questions, since the court called you and neither party called you. All right? Sorry I put you in this position, but I need the information you have, and only you have it. And I need to make a decision based on the best interest of this child. So, all right, Mr. Crow, if you care to proceed, sir.
Thank you, Your Honor. Good afternoon, ma'am. How are you?
I'm good. How are you?
Good. I'm very well. My name is Wayne Crow, and I represent Ms. Churchill in this case. And I'm going to be asking you a few questions initially to get a sense of your background and your experience in this area. Ma'am, you currently work at Michigan Assessment Services. Is that correct?
Yes, sir.
And how long have you been employed at Michigan Assessment Services?
3 years.
2 years. Sorry, you say 3 years or 2 years?
3.
3 years. Forgive me. It just came in a little muddled in the conversation. Okay. What kind of services does Michigan Assessment Services usually undertake?
We typically do substance abuse evaluations for individuals. Types. Sometimes we do them for the courts, sometimes for Department of Transportation, and sometimes for driver's license restoration with Secretary of State. So that's one primary component of what we do. We also provide supervised parenting time. Since I have that in my background, as does my colleague, Deb Denbor.
Okay, and how long have you worked in that capacity, supervising parenting time with Michigan Assessment Services? Have you been doing it the whole time you've been working there?
Yes, 3 years here, and then roughly 3 years at Journeys.
Okay, so you worked for 3 years previous to this at Journeys, is that correct?
Correct.
Okay. At Journeys, you did a similar role, is that right, in supervising parenting time?
Correct.
And while you were working at Michigan Assessment Service, how common is the supervised schedule that's currently in place, which essentially is at the homes of the respective parties? How often is that the supervised parenting time that goes into place?
Typically here at Michigan Assessment Services, that is the norm, because what we try to give to parties and court an option to have parenting time or community based. There's a transition, hopefully, that we're providing from a more structured setting at a facility to fill in that gap before someone does unsupervised parenting time. So that's the service we try to provide in that gap area.
Okay. And how many people work at Michigan Assessment Services?
3.
3. And what are the names of the people who work there?
Deb Denbor, David Baker, and myself.
Okay. And there was a period of time, I believe, at our last court appearance in which you were ill and you were not able to attend our last court appearance. Is that correct?
Yes.
Okay. And previous to the time, a subpoena was issued on March 6, 2024, was issued from my office to Michigan Assessment Services. Were you aware of the subpoena that was issued to that office?
Yes.
You were. And have you taken steps to provide to my office all phone record communications and your resume and curriculum vitae to my office?
No, I have not. It's
Okay.
my understanding that I would receive a second subpoena for that.
Why would
if you were so interested in that information, it's my understanding you had a conversation with my supervisor, Deb
Correct.
Denbor, about this matter. And it's my understanding that you would have recontacted our office requesting that, or at the least an invoice for the cost of that, as she discussed with you.
Okay, I guess,
So that's why
Mr. Crow, I should ask the question. Your subpoena was for her as a witness. Did it also involve a subpoena ducus tecum?
Yes. What we asked
Okay.
for specifically was both that she appear personally at that date and that she
Okay.
provide all notes and memos, all texts and emails,
Yep.
all phone record communications with Mr. Tenhor, and her resume and curriculum vitae, none of which was provided to my office. And
Was there a request for payment of that? Because I believe that's inherent in that they can ask you to pay for whatever.
there was not a request made of my office for anything.
Okay. In other words, that should have been done in writing.
So not only wasn't let me be very clear with the court. Not only was there not a request for payment made, it was specifically stated to me by the gentleman that Ms. Venhor just referenced that they did not intend on complying with the subpoena, and that he indicated to me that he did not believe that they had an obligation to do so. And I said to him quite clearly, we have provided a lawful subpoena to your office regarding this hearing, and that you have an obligation to do so. And he indicated that he did not intend on doing so. He did not think it was a proper subpoena, and that he didn't feel like he had to comply.
In that case, Ms. Van Zee, I would warn your superior that noncompliance with a subpoena can wind up with one of you two spending a weekend enjoying the bologna sandwiches as fixed by the local constabulary. So, yeah,
I'm not aware of
right.
a conversation with Mr. Baker.
Just make sure. Just make sure. Just make sure that happens, because Mr. Crow could have easily brought that in for a show cause before the judge, where fees, fines, costs, as well as attorney fees and potential incarceration until compliance is all on the table. Now, the judge probably would not throw somebody in jail the first time they did that, but if the judge heard what I just heard, and that's what the testimony would be on that, it wouldn't be a pretty sight. So you might want to tell them next time, contact the attorney, say, this is how much it will cost us to do this. Do we need to send you like a bill or, some kind of, but yeah, no, you guys don't get to judge whether the subpoena unless you're an attorney. Mr. Baker's not an attorney, is he? Tell him that he can add a sidebar of practicing law without a license in trying to interpret a legal document.
And so, Your Honor, the issue is, and I will certainly return back to my question of the witness.
Correct.
The issue is, Your Honor, is that these are all profoundly relevant to the testimony
yes.
in which this witness is going to give. And it is not as if, to be very clear, it is
Right.
not as if I sent this 2 weeks ago. Okay. There has now been close to 60 days in which there has been no attempt at all. By the way, and didn't get lost in the mail. There's an acknowledgement by the witness right now, an acknowledgement by the supervisor in the communication with me that they received the subpoena and they are electing not to. So, Your Honor, I did not show cause them simply because of the fact I recognize the fact that these are third-party witnesses and that she's the supervisor to this action. I don't have any strong desire to see.
Nobody does. That's why, although I gave the harsh warning, that's a warning I have to give.
Right.
But at the same time, none of us, as you can see, Ms. Van Zee, would ever want to do that. We realize your jobs are hard. They're not easy. But without those records, technically the court could strike all of your testimony. I am not inclined to do so. I am inclined to limit it to your observations of the interactions between the child and Mr. Tenhor and how that progressed over time. And that's why I called you.
And Judge, one more point which is relevant. If the court will recall, even back in December of 2023, my office had to file a motion asking for the matter to be adjourned because our witness here today sent over a copy of her report over to Mr. Tenhor 30 to 45 days before hearing date and was not provided to my office or my client.
And I realize I granted your objection to not allow her to testify. The reason that the court had to call her is because of testimony by your client and conflicting testimony of Mr. Tenhor. And I decided the easiest way to end that conflict was to hear from the supervisor. Because that way, that's the only reason she was called, because I did strike this witness at one point in time.
So, Judge,
but I do want to hear what she has to say about.
Your Honor, but I just do want to make a brief record if the court will allow.
You did.
I believe, yes, Judge. I believe that there's substantial evidence that was intentionally not being provided to me because it does show a significant level of conflict between that this witness had based upon her relationship with Mr. Tenhor. And now I'm in a circumstance in a situation that we are out on trial now. And I have submitted a lawful subpoena, which the witness just testified that she failed to produce, failed to provide. And now my ability to impeach the supervisor has been, I don't have an ability to do it.
That is why I'm limiting her testimony to observations of interactions between Mr. Tenhor and his child. That's exactly why I'm limiting the testimony.
I'm not going to
you may preserve the objection. I just want to hear, because from the testimony that I heard, so that you understand where the court is on this, it sounds like it was contentious at the beginning for the first month or so. But then it sounds as if it got better over time. Miss Churchill would like to hold it to the contentiousness that was in the beginning. But the testimony indicated that it got better over time, and I want a confirmation that it got better over time, or did it stay contentious? That is why Ms. Van Zee is here.
But just, again, not to belabor the point, and I'm not going to, simply to say this short.
Beside the fact that you've already belabored the point? Okay,
correct.
Please continue.
I'm not going to belabor it further than this. Only to say that my position in this case is that that the witness herself is not an objective observer in this case. And the problem is that I think that it is quite likely, although I don't know because I wasn't provided the evidence, that there may be an inappropriate, I mean that in the context of inappropriate for an objective supervisor, and her relationship and her friendship and the social interactions that she's had.
Those are what you have alleged, and they've been denied by Mr. Tenhor.
I understand.
I'm assuming you were going to question her on that.
Oh, I'm going to, but the problem is I wouldn't have to. I am now deprived of an entire slew of evidence that may approve these issues. And now I don't have it because the witness conveniently failed to provide it to me. So I will continue. But
what I will do is this. Ms. Van Zee, please have your supervisor or whoever received that subpoena send a bill or an invoice to Mr. Crow for how much it would cost to do all that. And then, Mr. Crow, all that information will be turned over to you, or you may show cause that.
And I will.
That person. And that will preserve the issue for an appropriate de novo if necessary.
Yes, sir.
But this has been stretched on since June of last year.
Yes, sir.
I would like to try and get a decision done in this somehow, some way. All right. So
Thank you for your patience, Judge.
I know you needed to make a record, especially now that I know why you needed to make a record. But again, the court called this witness, so the court would like to hear from this witness. So Mr. Crow, please proceed.
Thank you, Your Honor. And so, other than ma'am, since I did not receive your CV as requested, could you tell me what your educational background is?
I have a bachelor's degree in psychology and criminal justice from Michigan State University.
Do you have any other advanced degrees other than that, ma'am?
No.
Okay. And in Journeys, in working with Journeys for the 3 years in which you worked at Journeys, that involved you essentially observing the interaction between parents in a highly supervised setting. Isn't that right?
Yes.
Okay. And in that capacity, when you were working at Journeys, was it common for you to interact with the children and the parents while they were having their parenting time?
That would be determined on a case-by-case basis. There were a few cases where it was because the purpose for the visits were reunification, and there had been a significant gap in contact between the parent and child or children. So virtually the parent was a stranger. So the children were more comfortable with my interaction, and then I would slowly back out of that interaction once they started to become more comfortable with their parent.
I see. And in this particular situation, how many visits did you have you facilitated, or have you been supervising between Ms. Churchill and Mr. Tenhor?
So I have those visits identified on the first two reports that I did. Do you want me to?
So these reports, and let me clarify that with you, ma'am. So you issued a report on October 2nd, 2023, and you issued a report on January 31st, 2024. Is that accurate?
Correct.
Okay. And in the 6 months, or I guess the 5 months, a little less than 5 months since January 31st, have you drafted a new report that would provide context to what has happened over the last 5 months?
I have not.
You have not. Okay. So this isn't a situation where you provided the report to Mr. Tenhor and not to me, right? So there's just no report?
They're not.
Okay. So there is no written report. So basically, may I ask why you didn't write a report previous to our trial day today?
We don't do that unless that is specifically requested by one of the parties.
So in your 3 years of acting as a supervisor, how many times have you appeared in court before?
One other time.
Okay, just to understand this. So you've been working for 3 years at Michigan Assessment Service, and you've only had to appear in court on one other occasion for a custody case?
This is supervised parenting time, not custody, but yes, one other time.
And you said that was peer supervised parenting time, not custody. Forgive my ignorance. When you say peer supervised parenting time, would you walk me through what that means? Peer supervised parenting time? I'm not familiar with that expression.
I said that was supervised parenting time.
Oh, I'm sorry. I thought you said peer supervised. Your audio is kind of a little glitchy, so I apologize if I didn't hear. Okay. So other than supervised parenting time. So when you commonly do supervised parenting time in these cases, aren't you obligated to provide a report to the court? Isn't that sort of the point?
If the court requests that, I have not had a situation where that has been requested by the court. It's typically requested by one of the parties.
Okay. And so in the previous times in which you have issued a report, and I'm just thinking of the report, I guess, from October 2nd, 2023, you provided a copy of that report to Mr. Tenhor months in advance before you provided it to Ms. Churchill or my office. Isn't that right?
I would have to go back through our emails as to when I sent that to you. But I do know that I explained to Mr. Tenhor that it was his responsibility to disseminate that report to all the interested parties.
So to be clear, it was your policy and your position that you were going to send the report to Mr. Tenhor and just take him at his word that he was going to provide it to myself and to Ms. Churchill. Is that how you've been instructed to deal with these types of reports?
Well, he is the first individual that has been in pro se. So yeah, I told him that that was the procedure. If he wanted to use the report that I did, I don't believe he would be allowed to do so without also making that available to everyone interested, meaning the court and yourself.
But theoretically, you were providing the report to Mr. Tenhor, and you were giving him, I mean, quite frankly, a distinct advantage is that you were sending it to him, and even if he elected not to call you as a witness, or if the court didn't do it, he would have the report months in advance, and have the ability to prepare and determine his case and how to move forward in the matter months in advance over Ms. Churchill, wouldn't he?
Well, I think at the time there was a hearing scheduled within a few days of that report that ended up being adjourned. So it did end up being months in advance, but that was not how it was originally scheduled as far as the hearings and when this was requested and provided.
All right, but I mean, you had a report from October 2nd of 2023. The trial date in this case that did get adjourned, and it got adjourned because you didn't provide the report. That's what the judge, that's what the court decided, that since you failed to provide the information to my office and Ms. Churchill, that's why the case was adjourned. It wasn't adjourned for any other reason besides that, to be clear.
Objection. I sent you that the day after you requested it.
That's not a valid objection, Your Honor.
Well, it's a, Mr. Tenhor, you can do that on cross-examination. It's not necessarily a valid objection, but Mr. Crow, I've given you a lot of leeway on this. This witness was called for one purpose, not to beat a dead horse of a legal technicality.
I'll move on.
You've beaten that dead horse on more than one occasion. You were actually granted the relief allowed for that on one of those occasions. I got it. The only reason this witness is here is to give me the observation that she had between Mr. Tenhor and his child.
I'll move on, Judge. Thank you.
You've set a very good and lengthy record of the fact that there are some legal technicalities here. The problem is pragmatically, I need to know what's in the best interest of this child.
And again, I hear you, Judge, and I'm going to be moving on as the court is instructed.
Thank you.
It's just, it is difficult.
I know. It's difficult.
Because
the problem is that the court does not have those reports either. They're not entered into evidence. That's why we had her have to come and testify.
Yes, sir.
All right.
So, ma'am, you began your schedule of supervised access, would it be fair to say, on or about July 25th, 2023. Does that sound about right?
Yes.
Okay. And during the course of that parenting time, you had the opportunity to observe both Ms. Churchill and Mr. Tenhor. Is that correct?
Primarily Mr. Tenhor, but Ms. Churchill, those visits were in her residence, so there was some interaction that I was able to observe.
Okay. And essentially, tell me, what was your approach to the supervisor as the supervisor in the context of this visitation? How did you approach it?
Okay, I was going to say, I think Ms. Van Zee, it does not seem like you have a good internet connection. So what I'm going to do is have you go off video, because I need to hear from you more than see you. No offense, but normally the video does suck up. The video sucks up a lot of Wi-Fi, so hopefully that'll do it. Okay. All right, there we go.
Okay. And so So, ma'am, what was your approach to being the supervisor in this setting?
My approach was to observe, and I did make myself available to the children also, as far as helping with the comfort level, because it had been quite a period of time since I had seen their father. So I had met them once before, so not that they knew me very well, but at least I was familiar with them. But I primarily observed, I would say I had a little more interaction with them at Miss Churchill's home, because the children would invite me into that interaction, and I'm not going to ignore them.
Okay. And when you say that they would invite you into that interaction, can you explain that a little bit more? What does it mean for a supervisor to be
They would
invited?
they would come up to me with a toy and start talking to me about that or about something, showing me something they made or wanting my help to maybe open a package. And I would do that. They like to do projects, so some of them, one of the girls may want me to help with holding down a piece of paper perhaps while she was gluing and while Mr. Tenhor was helping the other child.
Okay. And these interactions that when the children would come up to you, is this because they perhaps had a certain comfort level with you based upon you being the supervisor?
They're very friendly children, very friendly and outgoing.
Okay. And so, ma'am, isn't it a fact that there were quite a few times in which the children, instead of coming up to Mr. Tenhor, would come up to you to ask you to participate in the parenting time rather than with Mr. Tenhor?
They may have done that, and I would redirect them at times. I may do what it was they asked. I mean, I can't think of a specific. I'm going from memory here. So there may be times when I may hold a doll because one of the twins came up to me with a baby doll and was talking to me about the baby doll needing to take a nap. So I may have held the baby doll. If she, say, wanted to change the baby doll's clothes, that would be something I would redirect the child to Mr. Tenhor. That's just an example.
Okay. And in your report from October 2nd of 2023, you indicated that there were times in which Mr. Tenhor appeared overwhelmed with the task of juggling 3 children with different needs and wants. Is that sort of what you're describing here today?
That would happen at times.
Okay.
When they would start acting out and being able to address their behavior, he would get over.
And that, in addition, that there were also, isn't it a fact, ma'am, that there were also times that you had to be the one to interject and provide guidance to the children because that guidance was not being provided for by Mr. Tenhor?
I wouldn't say that he wasn't providing guidance at all. It just may have been ineffective.
All right. So in your report, when you said there have been occasions when I have interjected and provided the guidance for the children by saying no or directly letting them know what was unacceptable, was that an accurate statement when you wrote that in your report?
Yes.
Okay. So indeed, that there were times in which that you were the one who had to provide meaningful guidance to the children. Isn't that right?
Yes.
Okay.
Mr. Crow, are we entering the report if you're quoting from it?
I'm not, Your Honor. I'm just using it for the purposes of
Okay, but
credibility of the witness.
you have the report at least.
Oh, I do have the report from October. I'm not entering it into evidence, though, Your Honor.
Okay.
To impeach the credibility of the witness.
All right.
And just referencing it. Thank you, Your Honor. And in addition to that, ma'am, when the children came to the visits, Did it appear to you that the children were well cared for by Ms. Churchill on a regular basis?
For the visits at her place as well as Mr. Tenhor's?
Yes, just your general observation.
Yes.
Okay. And just to kind of jump to more recent events here, how are there has been a bit of an interruption in the visitation over the last several months. Isn't that correct?
Yes.
And do you happen to know why these visits have been interrupted?
I myself was hospitalized for 8 days and off work for a month following. And during that time period, so there's some overlap with the reasons why parenting time was missed, beginning with my hospitalization. And during that time that I was not available, Mr. Tenhor had taken vacation, and then he was subsequently hospitalized as well.
Did Mr. Tenhor reveal to you why he was hospitalized?
He described some of, bottom, he said the physicians could not find, they were treating the symptoms, but they were not finding the cause of his illness. So it wasn't labeled anything. But he had severe inflammation, is my understanding, of certain vital organs.
Do you have, was any information provided whether or not there might have been an essential cause to this? It may not have been provided.
Not that I'm aware.
Okay. And so how long, if you recall, how long was this hospitalization for?
For him or myself?
For him.
Let's see. I know what missed parenting time took place, so there may be, I may be off by a day or two as far as the actual dates of hospitalization for him. But I have 3/19 until 4/2 that parenting time was missed due to his illness.
And there's been another recent hospitalization, has there not?
Yes, and that parenting time has not taken place from 5/13 to the present.
Okay, so from 3/19/24 to 4/12, and from 5/13 to 5/20, there has not been any parenting time
Due to his illness.
Due to the alleged illness, yes. Okay, that there has not been.
There was also missed parenting time on May 7th and May 12th. He was working on May 7th, and May 12th was Mother's Day.
Okay, so it seems that from our last court date, there have been several missed opportunities that Mr. Tenhor could have exercised parenting time that didn't occur. Is that fair to say?
Objection. I can't have parenting time when I'm in the hospital.
Again, that's not an objection. That's not a legal objection. What that is a cross-examination question.
Yeah.
And more importantly, pragmatically correct. I mean, the court can't force somebody who's hospitalized or undergoing medical treatment to engage in parenting time that might not be safe for the child.
Well, certainly not. And that's not my suggestion. My only suggestion is to confirm the timing of what we're talking about.
Right.
Okay. All right.
So we've got 2 months that she was out and about 2 months that he was out, all due to hospitalizations and illness.
Okay. And so let's talk about how the recent visits have been going, Ms. Vanzi. Let's say, since we don't have a report, let's go from the visits that did occur. And again, since I have no information, I'm just kind of asking in the blue here, asking in the dark. Isn't it a fact, ma'am, that the children have been expressing a certain level of discontent with the visitation as of late?
Let me see. Just maybe the last 3 visits, because they had been going very well. And then the children have been acting out significantly. the last, hold on, for at least the last 3 visits, to where I noted it. I will say this though, there was one visit where I was very surprised because it was out of character to have gone on, because usually what happens because all kids are kids and they may misbehave a little bit, not listening, and Mr. Tenhor will give them some guidance about what his expectation is, and they usually listen right away. On 2 occasions, 2 of the last 3 visits, one of the girls would begin the visit expressing discontent, saying she didn't want to be here, or that the place was dirty, something like that. But within 30 seconds, she was having fun and sitting on Mr. Tenhor's lap playing a video game and laughing. But there was one visit where it did go on, where I believe it was, I don't remember if it was Birdie or Sailor. I'd have to read through my notes, where she was significantly upset for most of the hour.
And so when the child said that she thought that she thought that the place looked dirty, or that appeared dirty, based upon your observation, is there any truth to what the child was saying?
No.
So the place is spick and span?
It's clean, yes.
Yeah, how would you describe the space in which he was interacting with the children?
It's his living room. There's a couch and a reclining chair, television. There's a couple bins with the children's toys that he has been slowly compiling for them, so they have things to do at his place, and a crate for a dog is also in the living room. Television, and stand.
So the children, are they allowed to play everywhere in the house, or is there only a specific area where the children are allowed to play in Mr. Tenhor's residence?
Parenting time takes place downstairs in the living room, the main floor in the living room. There is an upstairs that is 3 bedrooms only.
But the children are not allowed to go upstairs. Is that right?
Correct. He go up the stairs and they go in the bathroom up there. But he keeps his dog up there, and the bedrooms are for his stepchildren, and those are locked just for privacy purposes. There is one bedroom at one time that wasn't, so Mr. Tenhor let the children look at that and explained whose bedroom that was. But typically the children don't go upstairs, no. He keeps his dog there during the visits.
And so it seems that you know quite a bit of the backstory here too, ma'am. Is that fair to say?
I don't know what you mean by backstory.
Well, it seems to me that you have a little bit of an understanding about Mr. Tenhor's, about who lives in the residence, how long, what other children reside there. Is that fair to say?
Yes, I don't have it memorized, but yeah, he has written that down for me.
Okay. We've heard some testimony. We'll draw on. How often have you communicated with Mr. Tenhor outside of Ms. Churchill's presence? I know there's a group text. Do you often communicate with Mr. Tenhor?
Since the group text, no. I mean, I may here and there, like I did about his hospitalization, and wanting to know when he was going to be discharged, and I wanted to be sure that he was released by his doctor, because just because you're discharged from the hospital doesn't mean you're ready for parenting time to resume. And I wanted to be sure that he was released by his doctor before we did. So I may have some communication along those lines.
All right, so if we heard testimony that indicated that there was never a time that you had communication outside of billing issues, that would not be accurate, correct?
If there is, it's related to parenting time.
Okay. Would you say that this happened fairly often, or would you say it didn't happen fairly often?
Not often.
Not often. Okay. And so the children are only allowed to have only been upstairs once in Mr. Tenhor's residence. Am I hearing that correctly, or am I misstating that?
No, they've gone up several times.
Okay. And do you have any?
He just reiterates who the rooms and how the dog's in one of them, and we're not gonna stay up there. We're gonna come back downstairs and play. We're all up there on the landing together.
All right. And so are all the bedrooms in Mr. Tenhor's residence on the upstairs spoken for, as far as you know?
Yes.
Okay. So there are not any empty rooms. They're all right now filled with some of his other children. Is that correct? Or stepchildren?
Yes.
Okay. Understood.
Yes.
Okay. And so, one moment, Your Honor. So you testified a moment ago about the toys that are in Mr. Tenhor's residence. Are these toys that Mr. Tenhor has purchased for the children?
Yes.
As far as you know, at least, right?
Correct.
And are the children allowed to take these toys back to Miss Churchill's home?
Very little. He has explained to them that they're toys to stay at his place, so they have something to do when they're there. But he has allowed them periodically to take something small with them, because children can be quite insistent, and it is their things. So he has done that. I know there was an art project where the girls painted a couple of pictures for their mother and wanted to take them back home.
Okay.
I don't remember what other toys, but small toys. And also it would be something I would want her to be aware of and not make things more difficult for her, such as the toy being slime or something like that she has to worry about getting on things.
Okay. How big a role does video games play in the visitation?
That has been prominent for the last couple months since Mr. Tenhor purchased for Christmas time the Nintendo Switch.
Okay. So walk me through who's playing with the video games, who's not playing with the video games during these visits.
All four of them.
So are all of the children playing equally with this, or is there a time that one of the children are kind of left out, or two of the children are left out?
Okay, so that goes in and out. At first, it was usually all four of them: Mr. Tenhor, Birdie, Sailor, and Hudson. And Birdie generally sits on Mr. Tenhor's lap, and he plays for her. She loses interest the quickest, and because she doesn't do as well, so he plays her character for her. Sometimes both girls are disinterested and want to move on and do something else, and that's happened the last few times, and he's set them up with either a game or another toy that they enjoy doing. I know the art project, he purposely set that up for them to do, with the option for Hudson to also do that. But Hudson took the opportunity to play with the Nintendo Switch by himself. he enjoys that, and he's very patient with his sisters, but sometimes his sisters purposely frustrate him.
So if the point of the parenting time is for the gentleman to be reintroduced into the lives of the children, in your professional opinion, do you think it makes sense for video games to play such a crucial role in the interaction?
Yeah, playing them together.
I'm sorry?
And they're playing them together as far as talking and laughing about what each other does with their characters, what's happening on the screen because there's music. They all sing along to the music or think it's silly and laugh, and yeah.
Is that the kids under, as far as you know, and certainly not to repeat anything that they said, but based on your observations, is it your understanding that that's how the children feel about it? The children feel that they're being included in this whole video game situation at the residence?
Yes, they appear so, yes.
Okay. But isn't there has been quite a few times in which Mr. Tenor is playing video games, and then isn't it a fact that you've had to actually take steps in order to entertain the other children who are not included in that?
No, there's been one time I was handed a controller because Mr. Tenhor was opening, I think, he was helping another child with a toy. I know he's gone to get them water, and one of the children handed me the controller, which I have no idea what I'm doing, so they waited for him, and that was a joke. So no, he's very good about also letting Hudson know to wait a few minutes while he interacts with the girls in what they're doing. He'll go back and forth between those activities and share his attention.
Mm-hmm. All right. So in any given hour, about how much of that time is dedicated to the video games?
For Hudson, the whole thing, because he likes to play the Mario. There's 2 Mario games, and one driving game and one's like a world game, and then a Monopoly game that him and Mr. Tenhor originally were playing on a board game, and then he obtained the video version.
So how about Mr. Tenor? About in the hour, how much time is he spending on the video game system?
Like I said, he spends all of his time with them, but he will be doing Birdie's character when the girls, typically it's one girl, Birdie, will want to do something different, and he will share his time between her, Sailor, and Hudson. And Hudson's very patient about that too, and Sailor. When he does split his time, like I said, he splits his time with both the girls too at times, and him and Hudson will just play.
Okay. And so you testified that there are the last 2 or 3 visits in which the children had that when they came in that they expressed a certain level of discomfort. Am I recognizing your testimony accurately? Is that what you said?
Did you repeat that?
Out of the last 2 or 3 times in which the visit has taken place, the children have expressed a discomfort with the visitation. Is that fair to say? I just want to recast what your testimony was. Is that is that what you said a few minutes ago?
Yeah, discontent.
Discontent. Okay. Okay. And so
being grumpy and then acting out and then telling Mr. Tenhor, like maybe talking back with him, but then and here's an example. One of the girls said no to him, that she wasn't going to take off her shoes, and wasn't going to listen to him. But then 30 seconds later, she turned around and kicked off her shoes and ran into the living room to play, and was having a good time.
Well, I mean, so to be very clear, you know, in the previous reports you issued, we'll withdraw. I'm going to withdraw that. In addition, are you aware of some of the gifts in which have been given to the children by Mr. Tenhor?
Yes.
Okay. What type of gifts has Mr. Tenhor given to the children?
The girls have, I don't know the toy names, but they have maybe they're called My Little Ponies. They have several ponies, like ponies with the long hair that they play with and have accessories for.
I didn't think My Little Ponies were still a thing.
Yeah, they love those. They do. I
Okay.
had 3 boys. So that's this is a new world for me. But Prince's shoes, where they have a set, and he purposely got a set that had multiple pairs, so they wouldn't fight over the shoes. He knows that Hudson enjoys Mario, and I don't know all the characters, but Mario. So he got him a race car set with Mario and the other characters of Mario Brothers.
Mm-hmm.
Let's see.
And in addition to those items, he also provided the a bath bomb. Is that correct to his daughter? Is that right?
Well, there was a child spa set.
A child spa set. Okay.
Yeah, where each of the girls got a spa set.
Okay. And I just want to, if I may, do you recall on May 5th, the May 5th visit that you had with the kids?
Let's see, that would be the last visit. Yeah.
Correct. That's right. And so, do you recall some of the things that the children said about the visitation they were having at the inception of that meeting?
I know I was concerned, and I wrote it down in my notes. And this is that both girls were singing a song about the stupid man that lives in Holland. And they thought it was funny. And AJ let them know that the song wasn't very nice. And that was a concern to me because it was apparent that it was about AJ.
Okay. And in your experience, do those types of interactions, will that lead you to believe that there's been some positive growth in the relationship between the parent and the kids?
That there's been positive what?
Growth, and that there's a bonding going on between them?
It concerns me that they would put together a song like that, that would be unkind about their father.
And in addition, they've also said other things.
So more so that they wouldn't be dissuaded from that. That's my bigger concern.
Mm-hmm. And during the course of that last meeting, did the kids express the fact in one way or the other that they didn't wish to proceed with the parenting time on May 5th?
They did not say that.
Okay, so they did indicate that they don't want to be present. They don't want to be near the father for the parenting time. They never made that statement.
No, I know I was confused by a comment made by one of the girls that, let me see, let me look at my notes really quick. It was Birdie that said, if you don't stop saying that, her sister was going to run out the door to her mom. And I was very confused by saying what, and I asked Birdie that, and she didn't respond and continued to play the game, the video game that I'm playing. It came out of nowhere. There was no context for the comment. So I wasn't sure why she was saying that.
Okay. And so there has been some in the video before that on April 30th, there were also some issues. Isn't that correct?
Let's see. Yep.
And are these issues, these are issues in which there was actually some kind of physical fighting between the kids and the gentleman, is that correct?
Physical fighting between the kids and Mr. Tenhor?
Yeah.
No.
Is that not accurate? Okay. There wasn't a situation where the children were again expressing their displeasure with being there. Is that right?
No, what happened, it started out with Birdie was crying because she was saying goodbye to her mom and accidentally got poked in the eye. So she was a little emotional to begin with. No, the arguing started with the children yelling with each other while they were playing the video game. Like I said, Hudson's usually very patient with his sisters.
And
Birdie, who gets bored very quickly with the video game, has a tendency to try to frustrate him by pausing the game in mid-action. He got frustrated with her and went to take the controller from her in a manner that was so aggressive that she fell backward. At that point, Mr. Tenhor had all three children sit on the couch for a timeout.
And so how involved are you in reprimanding the children? And I mean, we're talking now, this is April 30th, 2024. We're almost a year into the supervised visitation, are we not?
Yes.
Are you still playing a principal role in interacting with the children and dealing with the issues with the children?
Not so much as I was before. I would say hardly at all. I will say I did step in with this after Mr. Tenhor already addressed the children and had them apologize for how they were behaving.
You had them do that?
He did that. And then I asked if I could also say something because I wanted the children to not just apologize, but to apologize to each other.
I mean, can I just ask?
They had really hurt each other's feelings, and I thought it might reinforce that a little bit more.
Ms. Benzie, this is now 10 months into the supervised visitation starting, okay? Do you think it's appropriate in your capacity 10 months in that you are still sort of assisting and managing the moment-by-moment interaction between a father and their three children?
If the situation warrants it, I will do that, but I have not been, it has been much less so than what it was in the beginning.
What has been much less so?
My intervening, if you'll, for lack of a better term.
Okay. But it doesn't really appear as if the relationship is getting better based on your testimony.
I would disagree.
You have a. I'm going to withdraw. I'll withdraw that comment. What I was about to say. And so.
I'd like to remind you, I'd like this wrapped up, and we only have 43 minutes.
I'm sorry.
I want to end this today.
No, Judge, I understand that we have a year. We have a year.
We have a year's worth, and I've heard a lot.
Yes, I understand, Your Honor. And would the court allow me just take a brief 5-minute break?
Certainly, and then I'll give you 5 minutes to wrap up whatever you're doing.
Oh, well, thank you, referee. I appreciate it. I will speak with my.
All right. Then we will recess for 5 minutes. I will. No, that's okay. When we started that discussion, you asked if we were off the record, and I said yes, we were. And I assume that in your closing statement, you're going to request to strike, or at the conclusion of this testimony, you're going to do what you requested, which is to strike her testimony. But I want her testimony on the record. We are also going to have to discuss at the end of this because I have not met with the children. And I can't remember because I do so many of these cases, and this has been going on a year. So did we ever state that children were too young for me to meet with, or did you want me to meet with the children?
I wanted you to meet with the children, Your Honor.
Then in that case, I will meet with the children, and I will have my clerk work with you, Mr. Crow, and your client. No offense, Mr. Tenhor, but she has more access to their availability than you do.
Sure.
So, and I want to meet with them. What I will do is I will meet with them in their bedrooms individually, and I will make sure that Ms. Churchill, they need to be alone. Nobody else in the room with them, not even the other children. So I'll meet with them one by one. And I realize they're kind of young, but there is case law out there, Quint versus Quint, which basically says if not the court not meeting with a 6-year-old can be a mistrial, which means we'd have to start all over. And I am not interested in doing that. I believe the appeals court's request was basically to the legislature to say, can you put an age limit on this, like we do an age limit for charging children with crimes? But at this point, the law just says that the court is to take into account the preference of the child. So I'm going to have to, unless the parties agree that the children are medically or mentally fragile enough not to meet with, or that the parties agree that the children are too young to meet with. But at this point, I'll meet with the children. All right. So we are on the record. Mr. Crow, I believe you were still in the matter of your examination, so please continue.
So again, the court has said that wanted me to sort of wrap this up, so I will, as the court directs, I will wrap it up. I only have a few.
Well, I've given you several days, so I want to get it done because I have 3 o'clock juvenile detention hearings.
Yes, Judge, and I understand that, and I certainly do not wish to draw the ire of the court.
You're not going to draw the ire of the court. You're going to keep me from doing something I don't want to do anyway. I'd rather spend the time with you.
I understand,
so,
Judge, and I appreciate that. Okay, so, ma'am, if the request is
Ms. Van Zee, you are still under oath. I would note that since we went off the record. So,
Yes,
all
sir.
right, proceed, Mr. Crow.
So, Ms. Van Zee, as it relates to supervising these 3 children, you have up to this point, it sounds to me that you've had to sort of continuously interact with these children during the parenting time. Is that fair to say?
I do interact with them regularly, and I would not say intervene, but I will not ignore them if they address something towards me.
Now, I mean, you indicate that you will not intervene, but I think in the issue when it came to that song that they were singing about, Mr. Tenhor, you did intervene, did you not?
No, Mr. Tenhor did.
Isn't it a fact, ma'am, that you actually told him to apologize to Mr. Tenhor?
No, I told them to apologize to each other when things had gotten physical between the children. No, Mr. Tenhor addressed that by telling the children that was not a nice thing.
I mean,
to say what they were singing.
So to be very clear, 11 months into you supervising this parenting time, you still feel that it is your role to actively, to essentially not just be an observer or supervisor, but it's your role 11 months in, to actively participate in this parenting time. Is that right?
If necessary, I have.
Okay. I have nothing further for this witness, Your Honor. Thank you.
Okay, thank you, Mr. Tenhor. Any questions of this witness?
Yes, I do. So seeing that, you've been around for 11 months now, wouldn't it be weird if they didn't want to talk to you or interact with you?
Right. That's why when they do address me, I'm not going to ignore the children.
Right. And it's not because you have to, it's just because we've been together for 11 months, correct?
They come up to me naturally, right?
Right. Okay. I want to talk about the transition time, from when the time that the children are dropped off from Brittany and usually her father to the time that they enter my house. How does that usually go?
Typically, it's gone very well. With the exception of the last few, But I wouldn't even say that starts to occur at the drop off. It starts to occur immediately at the beginning of parenting time, after they've been dropped off, within the first
Okay.
couple of minutes. But if you're talking about the actual exchange, the one thing that I would like to say about that is my desire to have both you and Brittany be more interactive during that time.
Sure, right.
But
So it would be
the
fair to say it's a little awkward. There's some tension.
yes.
Okay. And then how is their behavior once they're inside the house when the door's closed and there's no more interaction with Brittany?
With the exception of the last few visits, it has gone very well. They're very excited to be there. They're happy, easygoing kids, that look forward to the next adventure, and that happens to be.
I'm going to object to the witness statement regarding looking forward, unless there is a independent basis for that, Your Honor.
Okay. Mr. Tenhor, I'm going to have to ask you to re-ask the question based on the fact that we don't want to go into speculation.
Okay. I'll move forward. I'll move on.
No problem.
Do the children seem like they're apprehensive to be around me?
No, both girls very readily climb up into your lap, while you play the video game that you play. They laugh with you about different observations and things that are said when you guys are sharing things, whether that's the activity that you're doing and you're commenting on that, or if you're talking about their trip. They took a trip to Florida. I forget the destination and the things they do there. They seem excited to play with the things that you've provided for them, and the interaction has been going really well.
And then earlier, Miss Churchill testified that they find me creepy. Has that been your experience, that they seem to think that I'm creepy?
That would not be my observation.
Well, Your Honor, I'm going to object to that. I'm going to object to the testimony unless that's something that can be readily observed by the witness.
She just said it's due to her observation.
I understand, but to discern whether or not a child or any individual finds another person creepy, you're speculating to what is in the heads of the child.
I think you're the one that brought it up.
I'm not the one who asked the question, Judge.
Not that question, but you brought up the fact of the creepiness.
Yeah, but I mean, if
you're going to bring it up, then it gets to get cross-examined on.
Oh, I know, but yes, Judge. However you want to.
Okay.
You wish to proceed. No, but I disagree, Judge.
You can't ask a question, bring up a statement that basically you made, not even your client made, and consider.
I didn't make that statement, Judge.
I think it was close. So, but in any event, I'm going to let him.
No, my objection.
I'm going to overrule the objection because I believe that he needs to address that, because there was a tint of that in your examination. So.
And that's right. It's just that whether or not the witness is able to, what is the basis of knowledge for the witness's testimony?
Well, she seemed to have a basis when you asked the question.
I didn't ask this witness about.
No, you asked. I don't think you used the word creepy, but it was kind of similar. So I'm going to allow the cross-examine and take into account the fact that he's asking it as a lay, non-attorney party.
Yes, Your Honor.
So, but objection overruled. Mr. Tenhor, you may re-ask the question if Ms. Van Zee needs it, or Ms. Van Zee, you may answer it.
As I said, I haven't observed that with the children's behavior. One of the girls at one time, Mr. Tenhor, she would run up to him and he'd lift her up in his arms and swing her in a circle, and she would laugh and do that over and again. Another time when one of them may need to use the bathroom, he's there by the door. I'm in the kitchen, so I can observe and hear. They chat away with him while they're using the bathroom, without any apprehension at all. I don't observe their what I have observed is more of them feeling comfortable around Mr. Tenhor and readily going to him, like I said, sitting in his lap, playing games with him, laughing, giggling, and talking with him.
Mr. Tenor?
Yeah. So basically the point of our supervised visit was reintroduction, and it was to, get the children accustomed and used to me again. Julie, in your professional opinion, do you feel like that has happened?
That goal of reunification, yes, has been successful, I would say.
Okay. No further questions.
Thank you. Any recross, Mr. Crow?
Well, Your Honor, again, based upon having no information or discovery other than what the witness is testifying today, it is almost impossible to actively participate in this back and forth, Your Honor, because essentially information that I would use to potentially impeach her opinion has been willfully not provided to my office. But what I will say is this, Your Honor, ma'am, it's your testimony that that you do not believe that you believe the children are fully comfortable being around Mr. Tenhor. Is that accurately stated?
They appear to be comfortable. Now, when you use the word fully, I don't know and what, if that has a different meaning, because I wouldn't say entirely comfortable. There may be a situation when they may not be. I haven't been able to observe Mr. Tenhor with the children for more than an hour at a time.
Right.
So,
And
that may impact their level of comfort too. But yeah, what I have observed is for 80% or more, they show being comfortable with Mr. Tenhor.
okay.
And I have to add, the reason for why you did not receive the information you requested was not willful, and I just want to, for the record, state this mischaracterization of why you didn't.
Ms. Van Zee, let
I'm
me
moving
make a
forward.
legal determination that it doesn't matter whether it was non-willful or not. It didn't happen. The request was a legal request,
Correct.
therefore not. I did quote that law to you at the very beginning of this case, which is 722. And I will get to it. 2-3. I'm sorry, 722. In any event, the law basically says it is presumed to be in the best interest of a child to continue a relationship with both parents, and that you each are supposed to have a right to see these children. It's more paramount the children's right to know and get to know the parents, and parenting time must be ordered in a methodology to get that parenting time and the parents to know the children and the children to know the parents. You both have a constitutional right to parenting time, and to be a parent, the children have a constitutional right to know, a state right to know both of you. I will note that I reviewed 4 days of hearings, a total of 5.5 hours worth of testimony. There was only one exhibit that was entered. That exhibit were pictures from Mr. Tenhor of his relationship with the children. The witnesses were Carrie Robinson, a preschool teacher, Brittany Churchill, the plaintiff, her mother, I believe it's Robin, now that I can't read my own handwriting, Anthony Tenhor, and Julie Van Zee, who was the parenting time coordinator. This matter was reviewed in 2022 for a change of parenting time and sent to the front of the court. The front of the court subsequently entered a recommendation on February 6th of 2023, which was timely objected to by plaintiff Brittany Churchill. At that point in time, several hearings have been scheduled and adjourned, and we've held several. The first hearing in this matter was on June 3rd, and we've had several hearings afterwards, some adjourned and some didn't happen, or I don't believe the court adjourned any of them. There were requests by one party or the other. But at this point in time, I'm going to note that I made a mistake in the initial statement. After I reviewed the statute, I indicated that legal custody was on the table. It is not. No one argued for it. No one asked for it. There was no testimony to it. So the court will not touch that. Statutorily, the legal custody stays with the mother. By court order, physical custody is with the mother. And I must find before I make any orders that the custodial environment must be reviewed. At this point in time, the physical custodial environment is with the mother. There is no question as to that, Mr. Tenhor. And I will get into some reasonings about that. The court does not necessarily have to review any of the 12 best interest factors then, because custody is not in dispute. It's a parenting time dispute. Therefore, the parenting time factors would come into play. I am going to note a couple of the best interest factors, and I'll note why as we proceed. As to the parenting time factors, well, again, there is no clear and convincing evidence and no testimony that would change the physical custodial environment. The existence of any special circumstances or needs of the children, I believe they are vegetarian, but I heard no testimony to say that the father could not handle that. He has had limited time for several months, over 8 months, I believe. I don't believe he's ever had an opportunity to cook for the children, but it's my understanding that is part of his job. He knows how to cook. So I'm assuming he can take care of decent meals for these children and will be given the opportunity to do so. Therefore, that special circumstance is not a valid reason against him, and it holds to neither party. Obviously, mother has been dealing with that issue throughout the children's lives. The children are not of nursing age. We have a 7-year-old and 2 5-year-old identical twins. The likelihood of abuse or neglect of the child during any parenting time, there is no indication. Mom had some concerns that the defendant had a DUI, and that was 12 years prior, or 12 years ago, long prior to her having children with this man. She didn't have just one child with him, she has 3. So for her to complain that that is an issue from the past, her testimony as to his other issues that might be more current, no evidence was submitted other than mom's perceptions of that. Dad denied it during testimony, and it was indicative that I don't have any letters from the employer. I don't have anything stating that this is what happens. And since they have such a stretched relationship, it's hard for me to believe that mom knows so much of dad's life other than her own perceptions of what goes on in his life. So I don't find that there is any likelihood of abuse or neglect by the father in this matter, since we are going on parenting time with the father, not really anything with the mother. I will note that any parenting time standard that is ordered by the court does not affect the custodial environment of the children. But there were no CPS investigations or anything that was presented to the court that have any viability. A reasonable likelihood of abuse of a parent resulting in exercise of parenting time. Again, there is no evidence that there was abuse between the two parties. Disagreements, yes. Not liking each other, yes. Not trusting each other, definitively. I will note that Miss Churchill has basically prevented the father from being a father since the birth of these children. From her own testimony, she never really let him alone with the kids from birth. She never allowed him to become a father. She never allowed him to learn how to be a father. You can't set this up and then blame the other side for its consequences. That's not allowable in the law. You don't get to kill your parents and come to court and blame and throw yourself on the mercy of the court for being an orphan. You can't set him up to say, you're not seeing the kids, I'm not trusting you with the kids, I'm not leaving you with the kids, and then complain that he's not involved in the kids. The fact that he was gone for a year, from testimony, I could kind of understand the frustration of the only time you get to see the kids is if it's under your control, ma'am. That kind of control is going to push somebody away. I'm still not giving him any credibility because he did go away for a year. But still, there was also a year that he was fighting for this and has been, and it's been delayed by the court and by adjournments and by other things. So some of that is everybody's responsibility, not just his. But in that time, he also has gotten married, and has children living with him, and there are no CPS reports there. There's no complaint and no testimony that there's any problems there. The inconvenience to and burdensome impact or effect of the child traveling to and from parenting time, that is a problem. It is a 55-minute drive. The mother has been taking on all of that transportation. That will no longer be. It's going to be split between the parties. Mom chose to take on that responsibility, so some of it may still be hers, but I'm also making the responsibility of the fathers from here on out. And I'm going to deal with that in how I allocate how the parenting time goes. Whether a parent can reasonably be expected to exercise parenting time in accordance with the court order, I have no doubt that once granted, Mr. Tenhoer will exercise every time that's been granted, unless there is a work emergency or something of that nature. Whether the parent has frequently failed to exercise any reasonable parenting time, I've heard no just walking away from parenting time other than that year that he walked away. So no, I don't find that he would fail to exercise parenting time if granted, unless there's an emergency or a work-related problem, of which I would ask that there be a 24-hour notification that I'm sorry I can't make it. Whether the parent is frequently, I just dealt with that one. The threatened or actual detention of the child and the intent to retain or conceal the child. So far, the factors have been pretty well even. This one does go against the mother. The detention is not just the removal of the child or the hiding of the child. It is the restriction of the child. As noted in a previous finding, the mother has restricted this man's parenting time since his birth. The court will not turn him into a sperm donor. It's not going to happen. Continuing his continued supervised parenting time would be an invalidation of laws of the state of Michigan. It is presumed to be in the best interest of these children. He is no danger to these children. You complained at first that he didn't know the children. There are pictures indicating he does. There was a time period he was gone. I will note that he has a home. He has a place for them to be. It is not perfect. Mom has a great place for them to be. I'm not sure who she lives with other than the 3 children. I know that her mother and father are very involved. I don't know if she lives with them or not. There was no testimony as to that. I did meet with the children. I met with them in their individual bedrooms. They are very great children. They are very nice, but the court has grave concerns about how they talk about their father. Really grave concerns. And it goes to a potential interference or just an ability of the mother to not effectuate the father as to being a father. Some of the things those children said were problematic. There are other words I would prefer to use, but no, they're indicative of a parent that is not facilitating a relationship with the other parent. That violates the inherent rights of the children, not to have either parent disparaged by either party or third parties. I am gravely concerned about the ability of the mother to make sure that the father becomes a father. You chose him, not me. And sir, don't complain about her either. You chose her. So I have concerns about her facilitating this, and under the threat or actual detention, the detention would be the inability to facilitate that relationship. So at this point, I do find that there is no clear and convincing evidence. There is not even a preponderance of the evidence to prevent the father from having normalized parenting time. Now, that doesn't happen automatically. Some judges would just say, look, next weekend he gets every other weekend starting next weekend. We're not going to do that. This court works in the best interest of the children. So let me see if I can move this. I know the father tried to get the children to meet his current wife, which should have easily been done. Again, the warning that was given to you on June 3rd was, you control this or I will have to. I gave you the opportunity, and it's been more than a year, and this should have only taken 6 months. So there will be 4 Saturdays with no supervision, although I'm going to alter that just slightly because I've been thinking about this for the past 2 days. My initial notes said 4 Saturdays with 2 hours of no supervision. That first time, I'm going to allow the supervisor to be there to help facilitate the meeting of the stepmother with the children, Mr. Tenhoer, and possibly the step siblings. These people need to meet. So let's do that first one with the supervisor. Pursuant to Tiedemann versus Tiedemann, the court speaks through its written orders. This is going to take a few days to write that order. This order will begin parenting time of this nature. It'll stay supervised until this parenting time begins by my verbal order, which will take the same effect as a written order pursuant to Tiedemann versus Tiedemann. And that would be the first Saturday will be on the 15th because I want some time so that the kids are prepared. That first Saturday would be the 2 hours. Mom will drop them off. and mom will pick them up for these first 4 Saturdays. The supervisor may be there to help facilitate the meeting of the stepmother and or step siblings. Then there will be 3 Saturdays of 2. Again, mother is driving these first 4 sessions just to see how the 2 hours go. And understand, these children are going to balk. They're not going to do I'm not expecting them to do perfectly. This is a new situation, and a situation in which I think they have no doubt been told will be awful. Then there will be 4 straight Saturdays in a row. So this is 8 Saturdays now. The time will increase to 4 hours. The mother will drop off during those 4 Saturdays. The father will take them to the mother's home at the end of his time. So at the end of 4 hours, so you're going to basically get 3 hours with the children. That last hour will be spent driving the children back to the mother. Okay. And that will be for 4 hours. If the parties don't agree, that will be 12 to 4. Then there will be 4 Saturdays of 8 hours, generally 10 to 6. But if the parties agree to other times, that would be perfect. Again, mom will drop off, dad will return. After that first Saturday of 8 hours starts, and here's where the testimony contradicted. I note in the plaintiff's trial brief, she offered Thursdays, but testimony indicates that the children have dance on Thursdays till 6:30. She did testify herself. Her own testimony said that the Tuesdays were reserved for AJ, which I'm assuming is Mr. Tenhor, since those are his initials. So he will have Tuesdays at 5, where mom will drop them off, and he will have them back to her by 7:30. Sorry, it's only an hour and a half, but unless you move closer, and the kids have a bedtime, I'm stretching it a little bit because their bedtime's at 7:30. So I'm taking that into account, but at the same time, I'm trying to give some time here during the week because I don't want parents going over 2 weeks without seeing the kids. After those 4 weeks are over and the Tuesdays begin, the Tuesdays will stay a constant. After those 4 weeks are over, you'll start every other Saturday for 10 hours and and that's next Sunday for 10 hours. What we're trying to set them up for is the every other weekend, because that's where this is going. And that'll occur for 4 times, so that'll take 8 weeks to get over. All right, so that's 10 hours. Then it'll be, after those 4 weeks are taken care of, then it will be the 5th weekend after that will be Saturday at 10 until Sunday at 7 p.m. That'll be the first set of overnights. That will go for 4 times. So it'll be 8 weeks. Then, after those 4 times are done, it'll be every other weekend, Friday at 6 until Sunday at 7. Again, mother will drop off to the father's house. Dad will return the children to her house at the end of his parenting time. At that point in time, so this should be about Thanksgiving. Since the father has never had a holiday, we're going to start with, Thanksgiving to the father. I will send you, Mr. Crow, I think your office has my holiday time schedule. I will email it to you in a Word format. That way you can just incorporate it and it will line up. Now, spring break, one way or the other, I'm going to have to adjust this. So we're going to have to work on, because it's supposed to be every other holiday. Spring break for 2025 will be with mother. The summer of 2025, dad will have 3 full weeks, his weekend plus 5 days with the children for vacations. Mom will also have 3 full weeks. Dad is to send mom his 3 chosen weeks by April 1st. That way, if there's a disparity or a discrepancy, somebody may file a motion to confirm or deny that. Mom also gets to then choose her 3 weeks. Normally, preference will be given to the father in odd years of the 3 weeks. Preference will be given to the mother for her 3 weeks during the even years. Because sometimes things occur and people plan things out a year in advance. I am not dealing with child support. There was no testimony as to that. I believe Mr. Crow started down that road, but child support was not in contest here. And since I'm only granting approximately 70 or so overnights, the parenting time does not affect child support in any event. Child support can be reviewed if there's a change of income for either party or after 3 years. Since this order was entered into, I believe, in 2022, it may be reviewed early in 2025 again. That takes care of parenting time, the issues before the court. Mr. Crow, any questions?
I don't have any questions regarding the court's decision, Judge. Thank you.
No problem. All righty. And we'll try and get through that on a thumb drive if possible for you to review. That way you may type up the order. Mr. Tenhor, any questions?
Is Father's Day and Christmas and all that, that'll be in the
That will be part
FSD.
of the holiday time. That probably won't start just yet because we're starting the parenting time slowly over time.
Okay.
All right, that's for the benefit of the children, not for you. Like I said, there are some judges that throw the kids straight into every other weekend and start all that. I don't want to traumatize the children that much. I think there's more they need to get used to.
Yep, I
I
understand.
think once they get used to you and get acclimated to your environment, they will be fine. You can expect them to balk a little bit, Miss Tenhor. Sorry,
Yeah,
but you know, I have other comments that I will make that I will reserve if necessary for any future hearings.
I don't
So
have any.
I'm trying to make sure that I keep the parties on an even keel and that we move this along in accordance with the law. Like I said, the law has stated, and I told you this in the first place, parenting time is presumed. You control this or I will have to. I'm trying to control this as a soft landing to the children. Take care, everybody.
All right, thank you.